All right, let's get to the meat of the podcast, which is the Underdog Podcast. I like that. Don't you like that?
That is good.
You know, the gavel and the whole thing. The guy pushed it up, and
so a little Sisyphus.
Let's talk about a little underdog cases you've handled. The odds were against you. You know, you were up against a Goliath, whatever it is. Facts were tough. Why don't you talk to us about a few of those cases?
Sure. I can just talk. Some of them have like confidentiality in play, so I will try not to use names. But some issues that we've had in terms of hurdles, we had a big trucking crash maybe 7 or 8 years ago where our client had no memory of the crash. So we jumped on that case. We got a call early, fortunately. We jumped on that case right away. We got our investigator to talk to the other driver who told us that, yeah, she was making a left-hand turn at a time when she shouldn't have been making a left-hand turn. Our client was coming straight through a green at an intersection. And if we hadn't jumped on that right away and gotten that investigator to get that statement, I don't know if we would have gotten the same result, because when we deposed the driver of the truck, maybe a year after the crash happened, her story was completely different than the story she gave to the investigator. Just reiterating what I said earlier, that the most important thing is information, and the most important time to get that information is early.
Right. Yeah, I remember that one. Our client came in, told us that she had no memory of the crash. She was really messed up. Remember that, Pat?
She had a bad brain injury, in addition to a number of orthopedic injuries.
Right, and the other driver had a clear memory of the crash, and was saying the other lady, our lady, had made a left-hand turn right in front of her, which usually is a death knell to a case, right?
Yeah, that's certainly a bad fact.
So. Yeah, the resilience factor, just so you guys know, so the resilience factor is huge, because you can't make any assumptions in this business. So everything's got to be proven. If you're instructed by a jury in a personal injury case, it's proved by a preponderance of the evidence, which means more likely than not. But here at our firm, we have a much more strict, in-house standard, which is, hey, we're going to prove this, like, not beyond a reasonable doubt, but by a lot. So what else do you remember about that case?
Well, I just want to add, kind of on our theme of information can be difficult to get sometimes. I don't know if you remember this, Joe, but you were deposing the president of that trucking company, or I think he was identified as the corporate representative for the company at that time. And during the course of the deposition, which was about 2 weeks after our plaintiff's deposition, he told you that a week earlier he had purged his entire voicemail system, which means that they had recorded line for all of their drivers, so that when they called into dispatch, everything would be recorded, so they'd have be able to go back and find what somebody's issue was, or where they were stopped, or whatever. And he claims that he just hit purge, not knowing what it meant. But the fact that it came about a week after our client said that she had no memory of the crash was obviously a massive red flag, and it kind of blew up the case. And I think that they might have been looking for a short-term solution that caused them more longer-term headaches, and ultimately forced their hand to resolve the case.
So let me tell you how that one played out a little bit. So not only did we learn that this guy deleted all the voicemails, because the drivers were supposed to be in communication with the home office all the time. And they were all recorded, and he got rid of all that, deleted all that stuff. The second thing is there was a system they had in play that kept track of the vehicle's actual to and fro at all time through a computer, and they deleted that too, or never produced it. Then there was a point, that I basically said to Pat, okay, this is one that you're going to start rolling with. And I remember there was one corporate dep that was very interesting that you took. Do you remember that?
If I'm thinking of the same one you're thinking of, yeah.
So what happened in that deposition?
Yeah, so this was a few days after your deposition of the corporate rep. Mine was, or it might have even been a supplemental deposition of that same individual in a different capacity, whatever. But I was taking his deposition, and we spent about 2 hours going through what his procedures were, what his company policies were, all of these things that were clearly deficient in terms of following the safety regulations from the federal government. But he was not aware of that. He didn't know that. But then we confronted him with an application for a motor carrier license. So when you file an application for the motor carrier license with the US DOT, you have to certify under penalty of perjury that I understand the regulations, I've reviewed them, I know them, I have somebody in my company that is in charge of enforcing them and making sure they're being followed. And when I confronted him with that and said, you signed this document swearing that you had these things in place, did you have them in place? And at that point, he pled the Fifth Amendment, refused to answer the question. And that kind of was the beginning of the end of that case.
Yeah, I've never had somebody take the Fifth Amendment in a civil case. And so Pat was the first guy to get that done. So congratulations, Pat. Hopefully you'll have many people that do that in the future. But the key thing for that was, in my view, was that Pat was so dogged at getting every document from the personnel file, every document that they'd filed in either federal or state agencies, every document, etc., and had this big checklist. And he was going to make sure that this woman in the nursing home had the best advocate in a boardroom for her, to take care of her, to make sure that she was going to be taken care of for the rest of her life. And I'll tell you, when he came back, I may have been at that dep. I don't remember if I was or wasn't, but I just remember shaking my head, said, this is something else, is that we got a guy that, and they took it more than once, right?
You know what? He did only take it once because he just basically communicated, I'm not going to answer any of those questions. If I had to do it again, I was probably 4 years as a lawyer by then. If I had to do it right now, I would ask him 100 more questions and make him plead the Fifth 100 more times.
Yeah. And we videotape every deposition. So that was on videotape. And so that was not a pretty thing for them, but the case went on for a lot longer because it was a heavily contested case. And it was something that, they were not going to give up, and they were not going to pay, and they didn't pay for a long time. So, congratulations. Do you know? How about any other cases that you remember?
Yeah, we've had. I mean, anytime you get a trucking case, there are going to be complications with it, from both the liability side and from a damages and what the injury is side of it. The liability side, obviously, on every trucking case, you're going to have an expert saying everything was fine. We did everything according to what the regs say. And then sometimes you get things with injuries that, like we have a client in the unloading, our first kind of unloading case. We had a client who was a young guy, 30 years old, who he had 2 herniated discs in his back. So, if you're thinking, what would a reasonable person do in that situation? Well, if there's a surgery you can get to help fix it, you would get it. But our client refused to get it. And I completely understand why he did. He had family members that had bad history with back surgeries. There were other complications. So he didn't. And so I understand why he didn't get the surgery. But an insurance company now just looks at that as a back injury, no surgery. So he's just a file number with that code put into their system as to what the value of the case is. But as you get to know your clients a lot more and you figure out, the reasons why things are happening, like, for example, your decision to get treated medically or alternative treatments, you find out a lot more about the person, and it kind of helps you build a bit better case in a lot of ways. Because if he had gotten the surgery and he was, fully fixed, nobody's ever actually fixed after a surgery, but that case would have gone one way. And the fact that he wasn't able to, and it's something he's going to have to deal with as a new normal for the next, 50, however many years of his life. In some ways, that was what I viewed as a hurdle actually ended up being like something we stressed and highlighted, that this is just something he's going to have to deal with forever.
Right. So one of the things that we teach here at our law firm is to not run away from stubborn facts or tough facts and just, and just embrace them, because our whole thing with the jury is we want to make sure that we're the truth tellers and we're the ones that are explaining to them why this is in front of a jury, as opposed to, hey, we're here to hit a lottery or something like that. None of that ever happens. That's defense propaganda, etc. What we're trying to do is make sure that our person is put back whole to where they would have been prior to the crash. And so in that case that Pat was talking about, the fella had, it was a serious injury he had. I mean, he had 2 herniated discs that he felt 24 hours a day, 7 days a week. He was a guy that worked with his hands, and was going to have to deal with that the rest of his life. And so his medical bills were lower because he didn't have these surgeries and anesthesiology and all this physical therapy, all this stuff that, because what he had couldn't be fixed properly. If they would have gone in and done the surgery, it could have been more complications for him, because back surgeries, there's no guarantee on any of that stuff. I mean, I'm grateful for all those surgeons that do that, and I'm hopeful that they are all successful. But we've seen a ton of clients where it's been, maybe stopped one problem, but then they got another problem. So that type of finesse in dealing with that type of case. How about some other cases? Do you have any other cases that were kind of underdog for you that you felt, hey, I felt like you did the right thing and came through for people?
Yeah, I mean, a lot of our cases just feel like underdog cases because we're dealing with individual people, and oftentimes we're suing corporations. So they have, all of the resources. They've got insurance money. They're willing to go spend to find some of the best experts in the country, and trust me, those experts are willing to say whatever they need to say. So yeah, in a lot of ways, every time we have a trucking case, it feels like an underdog because it's just a couple of lawyers. It's usually me or you or Robert going against the might of an insurance company. It's kind of what drew me to law, because initially I was thinking about being a criminal defense lawyer, and I was like, I'd like to be in the one person in someone's corner against the weight of the government. And so I ended up finding that, but just in a little bit different pathway.